as office of the DPP, were not aware that the accused person stroke applicant was arrested from Nairobi. And my lord, it is common knowledge that the office of the DPP is not privy to what happens to general court martial, because general court martial falls under military justice system. And the office of the Director of Public Prosecutions under Article 120 of the Constitution is in charge of civil justice system. In that, my lord, as office of the DPP, were not aware that the accused person stroke applicant was arrested from Nairobi. Next, please, Lord. Birivumbuka, Chief Secretary for record. For prosecution stroke respondent. We'll give a brief reply to what the applicant has said. We'll give a brief reply to what the applicant or A1 has presented from the start to the end. It will be very brief. Thanks so much. My lord, as the prosecution or as the office of the Director of Public Prosecutions, we took over this matter by way of fresh investigations if I recall well, between 11th and 12th of February of 2025. 11th and 12th of February of 2025. And we charged the three applicants stroke accused persons before Nakawa Court Chief Magistrate on the 21st of February 2025. And my lord, it is common knowledge that the office of the DPP is not privy to what happens to general court martial, because general court martial falls under military justice system. and the Office of the Director of Public Prosecutions under Article 120 of the Constitution is in charge of civil justice system. In that, my Lord, as Office of the DPP, we are not aware that the accused person stroke applicant was arrested from Nairobi. Because we are not privy to military justice system. My Lord, after charging the applicant stroke the accused persons on the 21st of February 2025, we committed them on the 29th of May 2025. And my Lord, it is not true that the applicant was committed without legal representation. His counsel appeared on that date and in record of the Chief Magistrate of Nakao. They just decided to walk away in protest. An act that would not in any way, my Lord, affect the procedure of committal of the accused person to the High Court. Because the substantive justice before Chief Magistrates Courts in capital matters such as this one is either commit or release the accused person if you're not ready to proceed. And by that time, my Lord, the investigations were over. And now the Office of the Director of Public Prosecutions was to simply exercise its mandate under Section 168 of the Magistrates Court Act. After committal, my Lord, prosecution was ready to have the accused persons or applicants tried. However, as rightly put by the applicant, one senior citizen, Dr. retired, she's a Besigye. They bombarded this honorable court with several applications. Some of which made the hearing of this case at that time practically impossible. So we've actually wasted about 6 months in applications, my lord. This is not to say that the applicants or this person do not have the right to make those applications. We appreciate that it was all within his right. But our argument is that those several applications affected the fair trial, I mean the quickest or quick trial of this matter. My lord, we started disclosing this matter right from January. And my lord, what was remaining were basically about 5 statements. For witnesses whom we thought we at risk of intimidation, harassment, and compromise, among others. It is on that basis that we filed a an application, sorry my lord, an application for protection my lord. The deponent in that application, the land Chief Secretary Joseph Chomhendo, was cross-examined for 2 days, if not 3, almost. Because prosecution, my lord, was interested in a quick and speedy trial, no disputing fair trial, we decided to withdraw that application. Much as protection of witnesses is part of the fair trial. So we compromised protection of our witnesses for the sake of having this matter heard. After withdrawing our application, we fully disclosed the remaining 5 witnesses. The statements for those remaining 5 witnesses to defense. And we intimated to them, or to this court, my lord, that we are ready to have the matter kickstart. Defense brought another issue that we had agreed to some issues or facts which prosecution never had. And they were raising them, but they were not specific with those issues. And because of that, my lord, this court made an order that prosecution brings or presents its witnesses. We brought our witnesses, my lord. We brought 2 of them that time. Although for their statutory reasons they were not in this honorable court, but some were very close to reach of this court. The applicants struck their happy persons filed an application for human rights enforcement. Against General Mhoz and and 3 others. My lord, on the 11th of June, this court gave out schedules. Gave directives on schedules in that application. And my lord, the main case was adjourned to the same date of the hearing of that application on the 30th of June, 2026. My Lord, on the 30th of June 2026, court fixed the bail applications for A1 and A2. That is license application number 213 of 2026, and also license application number 0698 of 2025 for A3. My Lord, the reason why these applications were fixed is because counsel for the applicants stroke accused persons had requested the court previously to have the same disposed of. So the demand was to dispose of the said bail applications, the human rights enforcement application, and then they also asked for facilities to be availed both at court and in the prison. That is the reason why, my Lord, the two bail applications were fixed. And also, in order to address the issue of facilities, this court, the accused persons wrote to court, and court wrote to prisons. But I will come to that later, my Lord. Let me first finish up the issue of the bail application. My Lord, on the 30th, court issued the directives that the respondent files their reply by 1st of July 2026, and the applicants make their rejoinder on the 2nd day of July 2026, if any. And then it was fixed today for hearing at 2 p.m. My Lord, just to remind this court and the accused persons is that on the 30th day of June 2026, counsel for the applicant stroke accused persons, led by counsel Kugumi, informed the court that they were ready to receive the directive or directives or schedules. And that's why this application was fixed today, or the two applications were fixed today. My Lord, this application, that is 213, okay, was not solely filed by Senior Counsel Martha Karua and Senior Counsel. I think it was filed by so many. It was a joint application, if I remember very well. Okay, Council the firm for Senior Counsel was part, but there were other firms which worked very hard to file this application. Council Tugumi on the 30th of June 2026. Maybe let me just make it clear that neither counsel for the applicant nor the applicants expressly informed this court that this matter wouldn't take off today. We appreciate that the issue of representation came up, but they were not to the point that this application would not take off today. And as a result, my Lord, the respondent complied with the directives. We filed our response by 1st of July 2026. My Lord, as it has been a culture between counsel for the applicants and as counsel for the respondent, we have been having a cordial relationship in terms of service. Much as ECMIS, when you file on ECMIS, the other party is deemed to have been served. We have been having that cordial relationship that we normally serve the hard copy of our pleadings. So it is because of that relationship that we thought we could serve counsel in this matter. To our surprise, they say they cannot receive our service because they had no instructions. We were surprised, my Lord, because we hadn't seen anything on record for withdrawal of instructions. And that was the basis of the respondent serving the applicant's counsel. So, my Lord, as we came today, the respondent is ready to have this application prosecuted. And my Lord, in matters such as this one, it is normally the applicant who should be interested in having the application prosecuted. My Lord, before I go to the tail end of this application, I just wish to say a few things. The applicant raised the issue of Council Club being arrested. My Lord, we are aware that he was charged with misprision of treason. However, we are not aware that he was arrested by General Moses. We are not aware, my Lord. And we are also, my Lord, not aware that Senior Counsel Martha Karua, whom we respect here, was deported and declared persona non grata by General Moses. My Lord, we have always respected the representation of the applicants, stroke accused persons, and we shall respect that because it forms part of his constitutional rights. My Lord, the applicant submitted that he sympathized with his legal team and as such relieved them of their duties. I hope I got him very well on that. And he said that until the recent application concerning his representation is addressed, nothing actually happened, and is willing to stay in prison. My Lord, it is a submission as respondents. That since the applicant is anxious to leave prison, then you should have allowed to have this application prosecuted. And my Lord, we are inclined to submit that this court has powers under Section 37 of the Education Act to give any remedies to the party before it, and my Lord, our remit is under Section 72(2)(a) of the Education Act. I mean 17(2). Section 17(2). Section 17(2)(a) of the Education Act, Cap 16. To have, my Lord, this application dismissed. This application, my Lord, can always come up. Because as respondents, we are not aware of the application in respect to his legal representation. So it would be hypothetical and speculative on our part, my Lord, to start scrutinizing the merits of that application at this level. So this dismissal, my Lord, is intended to curtail any delay in trials. Which emanate from abuse of the legal process. This is not to say that the applicants, that as respondents, we don't believe in the applicants who apply for them. We believe in that. And that's why, my Lord, we work tooth and nail to ensure that we file our response by 1st of July 2026. Under pressure by the reason was to ensure that we propel Article 28 of a speedy trial, my Lord. Article 28 of the Constitution, my Lord, in respect to speedy trial. So, my Lord, we so submit.
Responses to the things you raised. His understanding of what committal process should be in respect of the accused, I believe is not in line with the law. I think in a trial, the seriousness that has been so much talked about by prosecution itself, defense is entitled, has a right to be represented at all stages, and especially committal is a serious stage. It was our right to represent. Regarding disclosures, again the point was made here in court. That the reason we talk about full disclosure is that you can only know the whole case once you have all the information, not parts of the information. Though the disclosure began in January, it continued piecemeal all the way. But more critically, the main thrust, the essential element of the disclosures is in electronic documents. Videos and audios. Which, regardless of when they were passed on to our council, up to this day, as we stand in court, we have never received them, viewed them or heard them. Because the order for facilities to do so was given in this court day of June. The registrar, the deputy registrar, whatever the case, was supposed to communicate those instructions to the prison authorities. To the best of my knowledge, the instruction about facilities being accessed in the prisons to view these things has never been communicated by the deputy registrar to the prison. Unless, of course, the OC misinformed us. What the deputy registrar wrote, and the letter was read to us, was for provision of time in weekends and public holidays, accessing the prison in weekends and public holidays, period. And when our lawyers heard what was communicated to the prisons, they came back to the deputy registrar to inform about the problem that still existed. Since there is a letter in court with the prosecution, maybe they can help court to read to us that facilities have been allowed in the prisons, which would be news, not a news to me.
Can you read that letter? Can you read that letter? Pause.
My lord, there are two letters.
The one from Brazil.
Prison. My lord, this letter is dated 29th of June. It is dated 29th of June, 2026. 29th of June, 2026. My lord, it is addressed to the Deputy Registrar of Criminal Division, Kampala. I got it, my lord. And it is in response to the requests presented by lawyers in criminal session case number 335 of 2025, Uganda versus Colonel Retired Dr. Besigye and others. 1. Reference is made to Kampala High Court Criminal Division Deputy Discourse Letter dated 18th of June 2026. Reference guidance on requests made by lawyers in criminal session number 335 of 2025, Uganda versus Colonel Retired Dr. Besigye and others. 2. Below is the response to the respective requests. The lawyers of the accused persons be provided with unrestricted access to the prison facility from 8 a.m. to 6 p.m. to ensure preparatory meeting time as required for purposes of taking a full account of the events and identifying potential witnesses for accused persons and attending the facility with such people from time to time. Response: access granted from 8 a.m. to 5 p.m. B. Lawyers and the accused person to be provided with an interview room free of any officers of the state and which is large enough to accommodate 15 to 20 lawyers and any assistance to ensure that the advocate, client privilege, and necessary confidentiality is accorded. Response: the spacious room large enough to accommodate 15 to 20 lawyers and any assistance is available and will be provided. Second response: the client advocate privilege of confidentiality will be accorded with the prison officer being in sight but not in the meeting of the ongoing interaction as provided for under section 63(3) of the Prisons Act, Cap 325, regulation 54(3) of the Prisons Regulations 2012, and chapter 38 paragraph 8 subparagraph 5c of the Prisons Standing Orders Part 2 2017. C. Lawyers of the accused persons be permitted to bring into and take out of the facility on each day of consultation. A. Projector and whiteboard stroke background. Response: this will be provided. 2. Laptops, mobile phones, ear stroke, headphones, and mini sound speakers. Response: laptop, ear stroke, headphones, and mini sound speakers will be provided. B. The mobile phones are not granted entry into the prison, but can be kept at the outside visitor handling office where the lawyers can access them with ease. Mobile phones are key prohibited items in prison as per chapter 45 paragraph 2h of the Prison Standing Orders 2017. 3. Internet connection which is secure to facilitate on-spot research. Response: this is not granted in the lawyer's interaction room, but we shall avail an alternative nearby room equipped with internet accessible to only lawyers for research on need basis. D. An IT expert of the accused person's choice to assist in defense preparations be allowed to prisons with lawyers of the accused persons. Response: this is hereby granted, but upon full identification. E. A forensic examiner of the accused person's choice to assist in defense preparations be allowed access with the lawyers of the accused persons. Response: this is hereby granted, but upon full identification. Lawyers of the accused persons be allowed access to the facility with all case files, flash drives, notebooks, pens, statutory books in hard and soft copy as may be deemed necessary for effective consultations. Response. Grant of access is hereby accorded to all case files, notebooks, statutory books, big crypto ballpoint, pens, and flash drives containing only electronic evidence and soft copies of statutory books. G. Permission to access the facility with the necessary meals and refreshments for those attending the consultation sessions. Response. The refreshment that is packaged water is hereby granted for the lawyers. The accused person's refreshment will be got from their internal stock. While for food, the lawyers are at will to have scheduled meal breaks, as the accused persons also go back to their residence for their internally prepared meals. H. Lawyers representing the accused persons will be granted access with the required confidentiality to the accused person at court before commencement of every court session. Response. The interaction with the accused person, with the accused before court commencement is granted, but subject to security assessment and controls. Most obliged. Meet on TO for Commissioner General of Prison, CCPR.
Yes, I learned as you heard that letter is of 4 days ago. Certainly our lawyers haven't seen it to show those, because it came during the crisis we are talking about. And nonetheless, there is some progress that is registered in the letter. If and as we are able to reassemble a legal team, hopefully that letter will be made available to us. Is it copied to any of our people?
Yes, it was copied, my lord, to the Defense Council.
Yes.
And yes, and state attorneys. Yes, my lord.
On the surface, I could hear contentious areas, but I guess those will be dealt with once or if we resolve the question of the representation. Lord, the DPP continuously refers to speed trial, quick trial. And says they withdrew the tomb handle. Application for witness protection facilitate that quick trial. And expose their witness to risk which they were trying to protect them from. So, Mr. Judge, you can imagine they were seeking to protect army officers, senior army officers, and they are now worried about their security. Where does that leave our lawyers, who are directly threatened by the senior most military officer in the country. Military officers themselves needed protection. Can you imagine what we are faced with? Those who need protection against General Mohozi. On preliminary hearing, agreed facts is only one element of the preliminary hearing. All these others are part of that preliminary hearing. And agreed facts, if they are none, it's just recorded that they are none, but it's a legal requirement that if they are agreed facts, agreed documents, then the memorandum is worked out and signed by all parties. But to conclude preliminary hearings, when these other matters had not been dealt, including this application, including the access to the disclosures, because preliminary hearing and the trial was supposed to begin on 11 June. This letter, which is now giving access, is of 29th of June. And there rests our concern. That we are expected to come here on 11 and face a witness before we access the disclosures. I'm surprised, my Lord, that the DPP comments in the matters of our application for human rights, where he is not a party. Maybe the reality is that he is actually a party. When the Attorney General introduced prosecution, when he was introducing his team, we thought it was a slip of the tongue. Now, prosecution is telling us what happened on the 30th in respect of these proceedings of the application. if we were really interested, as we are, in getting freedom, liberty, our submission to you, my Lord, is that even the bail application cannot be meaningfully processed in the current circumstances that are not of our own making. Even our sureties are under threat. The Honorable Semujunganda, who is one of the sureties we presented in this matter, has been told he is the next one after Paul by the same general. I haven't seen him since. I don't know whether he's in hiding or not. If Council Togune and the few lawyers who were here on the 30th created the impression that they were the team instructed to continue prosecuting these matters, I think it was to the wrong impression. We met the lawyers before we came here. The court cells down here. And our clear understanding was that they were coming to raise the alarm about their situation. To indicate how the team has been decapitated and rendered unfunctional. If you are decapitated, Mr. Olutindo-Birivumbuka, God forbid nobody does. But if you are decapitated, you can't refer to the body as still able to continue doing something when it has lost its head. Simply can't happen. Because the body functions as one. Some parts are not as critical as others. You may lose a finger, you may even lose a hand to continue functioning. But when you are decapitated and the head is removed, you have to rebuild afresh. So, if an impression was created that by their presence, when they talked very clear and loudly in court in my presence here and all of us here about their dilemma. I think one said that he was even not sure whether he will get home here. Was counsel by, and I think, you know. So, Mr. Judge, our team is simply, whether there is one or two or three, they function as a body. It was rendered dysfunctional. Our attempt now is how to deal with it. Defense counsel definitely told you the truth, but there was no instruction to receive the response on bail. We don't have weakness ourselves. We don't even have access to it. If we had computers, if they have not communicated, I guess failure to communicate cannot be visited on us. I'm inclined to agree that prosecution does not know that General Muhoozi Kainerugaba is behind was responsible for the arrest of Council of Babu and for the deportation of Martha. I'm inclined to believe. And that is why we filed that application 248, so that evidence is adduced, show that he is responsible. The respondent is responsible for the terror, which we need to deal with. Regarding recommendations to dismiss this bail application, I think we've been very clear that we are very keen on bail. Indeed, if these applications had been heard in accordance with the bail disposal regulations that are in place today, this crisis would never have arisen. The bail disposal regulations which are in the Constitution, bail guidelines for courts of judicature practice, directions of 2022. They provide that bail applications should be disposed of within 30 days. If our bail application had been heard and disposed of within those 30 days since we filed it, we would not be here. pay. As I pointed out in the case of my co-accused, ngannyola, his application is of last year. So we are simply incapacitated to act because of the reasons I have presented to court, that we have challenges of legal representation and therefore of communication. We didn't receive your reply. We can't rejoin the reply. We are simply stranded. I've also indicated that even our witnesses, at least one of them, have been informed, is under threat. But one of the authorities, Honorable Semunjunga. So, my Lord, I leave it to the court